Good afternoon. Happy Friday. A subscriber sent me a couple different things, and the first thing he sent me that I found very interesting was a video that James Freeman recorded where James went to a Brownsville, Texas police department to do a FOIA request, ostensibly. He recorded the entire thing. The FOIA person had gone home. He started getting help from another gal. These it's just a room. It's a box, right, where they could probably lock you in or whatever. But out of this room, there's one door that goes into the police station. The FOIA gal and the other gal, the dispatch, I'm assuming, gal, they're behind locked glass windows, and they're secure back in their little areas. It's not like they're any danger of anything. It's not like Freeman could get back there. So he's recording, the gal's helping him, and a guy comes out of the back room. To make a long story short, identified as a police officer. He's got a badge hanging on a chain around his neck. He says he's the supervising officer. Tells Freeman that Freeman can't record in there, and when Freeman disrespects the officer, to put it mildly, I guess, the officer trespasses him. The officer kicks him out. Now, the subscriber who sent it to me as a ha ha ha. James Freeman got trespassed and cried about it. And I looked at it as an attorney and I said, well, I don't know that James Freeman doesn't have a cause of action here. If James Freeman decides to sue, I think James Freeman would get a settlement out of that particular interaction, because it appeared to me that everything is pretty arbitrary and capricious as far as what the officer was enforcing. Any building policy written would probably, what you would sue for is a 1983 lawsuit. You'd sue that whatever unwritten building policy the officer was enforcing is arbitrary, capricious, void for vagueness, overbroad. It allows the officer to basically act at his sole discretion on whatever he does. There is no standard by which an average person could know what is or isn't allowable and acceptable in that particular space, right? So, long story short, I think that if Freeman gets a reasonably good attorney, Freeman could get a 5-figure settlement out of it. I wouldn't be shocked if he got a 5-figure settlement. I wouldn't be shocked if he got like 50-60 grand, to be perfectly honest with you. And he sent a link on that. Now, he didn't send me a link to RC video, but he summarized it saying that RC has alleged that the order prepared by Chille's attorneys, ostensibly by Chille's attorney, and signed by the judge, is appealable. And this is in the case that he just won on the appeal to the district court. Now, I don't know if RC said that or not, but if he did say it, well, he really shouldn't have unsubscribed to me, because that's pretty You can't appeal from a district court appeal in Nevada. Any appeal taken to the district court from the justice court or the municipal court is done at the district court level. Now, if the district court is the court of original jurisdiction, then you could appeal from the district court to the Nevada Court of Appeals, and then potentially, I don't know if they could still, the Nevada Court of Appeals is a relatively recent thing. They used to go just straight to the Nevada Supreme Court. So I don't know if you still have an avenue that way. But what I do know is that you can't appeal from a district court. And you're going to say, well, John, what about Wilson? What about Wilson versus the, first district court? That was in a justice court case or a municipal court case. I don't remember which. Either way, same difference. That was appealed to a district court, and then all of a sudden, the Nevada Court of Appeals heard the appeal. Well, they didn't hear an appeal. What they heard was a petition for writ of certiorari, and it is different than an appeal. In law, if there are different words used to describe something, there is a high likelihood, if different words are used to describe something in the same court system, then they most likely mean something different. That's opposed to something like pro se versus pro per. Well, California court systems use pro per. Federal courts typically use pro se. They mean the same thing, but they're being used in different court systems. A petition for writ of certiorari is different than an appeal. And to vastly oversimplify it, essentially at the trial level, the court, at the trial level, there will be an interpretation of the law. There will be an application of the law. There will be a determination of what the facts are. There will then be an application of the law to the facts. So you have a determination of what the law is. You have a determination of what the facts are, and an application of the law to the facts to get the judgment. That's what happens at the trial level. At the appellate level, on an appeal, you don't have a determination of what the facts are. That's gone. So you still have the Court of Appeals can determine what the law is, and they can apply the facts to the law. The lower court determined what the facts were. The appellate court can still apply the facts to the law. On a petition for writ of certiorari, now you're down to the determination of what the law is. No one's going to tell the Supreme Court you can't apply the facts to the law. So don't get me wrong. I'm vastly oversimplifying it. But kind of what should happen is this is a review of the law, the Constitution, the statutes, the law. What they're doing is they're saying, did the Court of Appeals or the appellate court misinterpret or misunderstand the law? If they do, if the Court of Appeals does misunderstand the law, then the court that had the petition, that heard the petition for writ of certiorari, can send back the case to the Court of Appeals and say, okay, now that you understand how you're supposed to interpret the law, go ahead and apply the facts to the law. So from the trial court can render judgment, yay. If you appeal, it goes to the Court of Appeals. The Court of Appeals can do everything the trial court could do, except, generally speaking, it won't be determining what the facts are. It'll still apply the facts to the law, or the law to the facts, whichever way you want to say it. And it will come up with its own decision on what should have happened. Either they're going to affirm the lower court's decision, or they may enter a new decision overturning the lower court's decision. They may even remand it back to the lower court, but they don't have to, right? On a petition for certiorari, usually to like a Supreme Court in Nevada, you can file a petition going to the Court of Appeals or to the Nevada Supreme Court. You could petition for certiorari to either one of them. That's my understanding from the district court appeal. They would almost certainly only remand it. They'd say, here's what the law is. Now, lower court, now that we've told you what the law actually is, go ahead and apply the facts to the law and you'll be golden, right? So there is no appeal, is what I'm really trying to say. So if RC said that there was a potential for appeal on the order, no. And even if there was, purely as a matter of procedure, we would have seen something by now. So if RC is still making videos on Chille's appeal, he is either huffing or selling pure copium or hopium, depending on which way. I have my camera on the other side today, so there's a steering wheel in the way. Enjoy the back of my steering wheel, folks. So I hope I hope that makes sense. There's not going to be an appeal on Chille's appeal. Was the order well written? No. Did it say what it needed to say? Yes. I don't think even if there is a petition for writ of certiorari that a upper court will overturn the order, because in reality, unlike a court of appeals opinion, the appellate decision of the district court isn't going to be published anywhere. It's not precedent. Don't fucking worry about it. Just for those of you who are still like desperate to see Chille suffer for it, just remember what Elsa said, I think it was Elsa. Just let it go. Let it go. It's done. He won. That round's over. He got a win, guys. He got one win. It doesn't make him a winner. You could still say that he almost always loses. So just, let it go. Anyway, work is now calling me. Thanks for watching. Have a great day.